And two things. One, I wanted to thank you, and I mean that, for working with me procedurally. I want to thank my colleagues for voting to extend, because we do that as a courtesy, so thanks. Now, I'd like to request from the administration, if I could, that we as council members receive a written report of what exactly is going on in Austin. Short of reading it in the Chronicle, I have no idea what's going on. I have no idea what money we're spending. I have no idea who's representing us. I think that lays out what I'm looking for. What are the city's goals? What are the city's objectives? And, you know, someone may say, well, we don't do this on other lawsuits. Well, maybe we should, and we'll have that discussion publicly.
Councilmember Sullivan, I would add also, why don't you get the transcript and the evidence too, because that tells the whole story.
Only if you pay for it.
No. Mike already did, okay. but it's public record, so I can get it for free.
There's a point of order. Point of order sustained. Councilmember Sullivan.
Yeah, thank you. And then I wanted to ask our speaker, and certainly the city attorney can chime in on any of this. I'm not trying to box you out, Mr. Feldman. I have no agenda here except to just talk about the issue publicly. Going back to the Prop 1 lawsuit, I believe that's still in court. And if it is, Prop 2, it's still in court, what do you know about it? Who are the parties?
Is there a representative, Mr. Green, here today?
Would it be appropriate for me to ask him that, or I can ask you and you can ask him?
You have asked him, and he may answer.
Okay, thank you.
I seen a memo where Controller Green said that he was terminating his accounting of Proposition 2. And I want to tell him and the rest of the council, that's absolutely a preposterous thing to do. Proposition 2 is still in court. Mr. Hosey can testify because he was the plaintiff in the case. They won at the trial level in Judge Hallback's court. They lost a motion at the appellate court. They appealed to the Supreme Court. That ruling is up. It's about standing, and they're expecting that ruling from the Supreme Court any day. So Proposition 2 is still ongoing. The comptroller's office has gotten bad information from somebody that somehow that lawsuit's over with, because that was also testified in the court yesterday as well.
And Councilmember Sullivan, we're still on your time.
Oh, thank you. Where do we go from here with my request? Is it something, I know you're not mayor, but...
And we do have the city secretary with us at this time. If you would like, we can recognize, the city attorney. Mr. Feldman.
Thank you, Madam Chair. There's always a certain risk, council members, when an individual who is not a lawyer, but who is represented by a lawyer, comes before a public body such as this and suggests to tell that body about what the law is and what legal proceedings have transpired. I can answer all your questions, council member, with respect to this matter, and I can clarify and correct some of the things that Mr. Bettencourt has stated as city attorney. My only regret is that Mr. Michel had to leave earlier. I take exception to his name being used in vain to some respect by Mr. Bettencourt in connection with the advice that he gave this council. First of all, the action, council member, was brought under what's called the Expedited Declaratory Judgment Act, a statute that was passed by the Texas legislature in 2007 to enable taxing entities to obtain validation of bond issuances and matters related to bond issuances in an expedited fashion, because what we're experiencing, and I can certainly speak to this since I've represented governmental bodies for 33 some odd years, what we were experiencing was that bonds would be passed and there would be a plethora of litigation in a variety of forms regarding the bonds sometimes. So this legislature set up this process so there could be one lawsuit in one forum, and any other actions that were brought would have to be consolidated into that forum. The legislature also provided that such an action, an expedited declaratory judgment action, can be brought in the county in which the taxing authority was located or in Travis County. I can tell you that it's been my experience since the passage of the statute that with very, very limited exception, all those actions, regardless of where they originated in this state, whether it be West Texas, East Texas, North or South, have been brought in Travis County, for the simple reason that the Travis County courts are more accustomed to those types of proceedings. They have judges whose entire dockets are devoted to administrative type proceedings. So when the City of Houston chose to bring its expedited declaratory judgment action in Travis County, it was doing the very same thing that many cities, counties, school districts, and other public entities have done since the passage of that statute in 2007. The other thing I'd like to state is that there was no summary judgment motion filed by the city yesterday. Mr. Bettencourt, you can shake your head. I am a lawyer, and I can speak to the procedure that was utilized. What happened was, at the close of the intervenor's case, and Mr. Holtze and Mr. Bettencourt were intervenors, and in this special type of action, the intervenors have the burden of proof just like a plaintiff. At the close of their case, the city made a motion for directed verdict. We've got 4 lawyers at this council table. They all know. I mean, 5 lawyers, excuse me. They all know.
I'm sorry, Mr. Feldman, we have a point of order. Chair recognizes.
Suspend the rules, extend to speaker.
Okay, that's a separate motion. Do we have a point of order? Chair recognizes Councilmember Rodriguez.
Just like to invoke the council rules that we have one person at the podium.
Okay, thank you. Yes, gentlemen, we do have city council rules here, and point of order sustained. We'll have one person at a time at the podium. Chair recognizes Councilmember Sullivan for the motion.
Yes, ma'am. I'd like to make a motion to suspend the rules, please, so the attorney can continue.
We have a motion to suspend the rules to extend councilmember time by 5 minutes. Motion and a second. Any discussion? All in favor say aye. All opposed, no. Motion carries. Mr. Feldman.
Thank you, Madam Chair. As the 5 lawyers at this table know, that at the close of a plaintiff's case, it is customary for the defense to move for a directed verdict. That is what occurred yesterday. The court did not deny the motion for directed verdict. Rather, Judge Jelenowski, who heard the case, carried the motion with the case, which, as all the lawyers here know, is not an uncommon thing for a court to do. He did not deny the motion for directed verdict. He carried it with the case. The city then put its evidence on. The matter concluded at approximately 5 p.m. There was some argument from counsel at that point in time that the court asked for. The court then invited the parties to present briefs by Friday, which will be done. Then we anticipate the court may likely rule early next week. The council member, in answer to your question about who is handling the case, the decision was made in April before I became city attorney that the case would be handled by the firm of Andrews Kurth. I haven't received a bill from them yet, so I can't tell you exactly how much it's costing us. However, they know how stingy the current city attorney is, so I think that they're watching their billings carefully. In fact, a couple of them assured me that their presence, I placed a limit on how many lawyers could attend. And they assured me that some of them were appearing pro bono on behalf of the city. Following Judge Jelenowski's ruling, which we anticipate next week, if the matter is taken up, if the city prevails, as I believe it will, the matter is taken up by Mr. Bettencourt or Mr. Holtze, then they're going to be required to post a bond, and there's going to be a separate hearing regarding what the amount of that bond would be, because, as you might imagine, in a situation such as this, if the proceeding delays the issuance of bonds by the city, that's something that could be costly in terms of affecting credit rating, et cetera. So that is the process that has gone on to date, and I'd be glad to answer any of the questions that council members may have.
Okay, thank you, Mr. Feldman. Chair, have you concluded your remarks? Chair recognizes Councilmember Bradford.
Thank you, Madam Chair. Mr. Bettencourt, let me take you back, if I may, please, because when Councilmember Wong asked you some questions, that was kind of a rapid exchange, and maybe the citizens at home listening didn't catch it all. I didn't. Would you please slow down and answer this question for me? It has been represented that this rate increase is going to cost about 12%. Tell us, what is this rate increase going to cost taxpayers? And 2, how does it violate Prop 1?
Councilmember Rafter, thank you for your question. What I responded to Mr. Long is that we believe that the increase is substantially higher than the Proposition 1 limit, which was set at inflation and population plus bonded indebtedness. There is no rate that is charged that is for residential customers that is on the spreadsheets that were given to council that is not greater than 12%. Every single line item by 1,000 gallons of consumption for a residential homeowner, the lowest rate there is 12.5%, the highest rate is 24%, the average rate is probably close to 18%. The city's financial director testified that it would be a 40% increase over 3 years. And there are 3 subsequent increases and 1 year increase. They're about 18% in total, compounded together is 40%. The apartment owners and their residences are paying about a 24% rounded up increase immediately effective as of June 1st. And the question the council member asked me, because I've got a pretty good memory, was, do I agree with then city attorney's advice that this would not be litigated? And I said, false, I would not agree with it. And Mr. Feldman did not take the man's name in vain. I strongly disagree with that characterization, sir. Now, back to your question. The result is an increase of this magnitude is clearly in excess of the Prop 1 limits voted on by the public in 2004, which is why Mr. Hossein and I didn't agree. So if you're hearing numbers, you need to understand that these numbers are much higher and are going to get higher in the future.
Second.
Thank you. We have a motion and a second to suspend the rules and extend the time. Any discussion? If not, all in favor say aye. All opposed, no. Motion carries. Councilmember Bradford.
Thank you. Mr. Bettencourt, thank you for fighting up for the taxpayers. Someone has to do that. Thank God you have the resources to go and fight and speak up for the taxpayers here. I'm concerned because what was represented to us as a need to cover the O&M in the system was presented on the table as one figure. Then, in an impromptu fashion, there was an additional motion added to the package to increase single family, which brought in an additional $44 million. So that couldn't have been based on what was in the study, because I remember specifically that motion was kind of impromptu to just add $44 million on top of what was already on the table, represented to be O&M costs. Your response to that, please.
That's the exact number of the pad that I'm talking about. In 2009, by your audited financial statements by the city's CAFR, the O&M of that department, or that fund, was $371,771,000. The study, all in 1 year, all on its own, said that the new number for 2010, the base year, the year we're in right now, would be $415,577,000. So that's a 12% increase. It's also interesting to note that when the city sells bonds, they claimed on a bond issuance that in 2010 as well, that number was $351 million. So we're telling the bondholders that the O&M cost is $351 million. The city's financial statement is saying that for 2009 it's $371 million. And then in 2010, your study, which we believe is flawed, by the consulting company, increases that number to $415,575,000. You're absolutely right. I don't know how you increase your operating and maintenance expenses 12% in a recession. Are chemicals up? Or did you hire a bunch more employees? The city's own director there said that, in his testimony, that's not what occurred.
Thank you for coming down. I have an additional question for Dr. Host on Proposition 2, but thank you for what you're doing. I appreciate it. Thank you, Madam Chair.
Thank you.
Thank you, Mr. Bettencourt. That concludes the comments for you.
And Mr. Bruce to be followed by Ms. DeYoung.
Good afternoon. Thank you guys for hearing me. I've been here before trying to take care of spending and controlling spending, and I never thought that I'd be fighting the city on Proposition 2.